Our community development public hearing, February 9th, 2023. The time is 6 p.m. I'm calling this meeting to order. In attendance are Commissioners Brooks, Matari, and Duncan. Are there any changes to the agenda? All right, hearing none, I will poll for a conflict of interest.
No conflict.
All right. And we will get started with our one and only action item, which is ZON 21-0002, Kellner Zone Change Reconsideration. And Amy, are you going to start us off?
Yeah. Can everyone hear me okay? I speak a little quietly, so. So this is a request for reconsideration for the zone change application ZON 21-0002, a request to rezone from agricultural to rural. The board had originally denied this request. Just as a quick recap, the decision was a 1-to-1 decision. There were only 2 commissioners present at the decision, so without a consensus, it did result in a denial. Oh, doesn't want to work. 1 sec here.
Amy, do you want to sit there and speak? Because you've got a microphone.
Oh, and you can use your actual mouse too.
Yeah, let's do that. This is brief introduction. There we go. As a general rule, the order of the presentation for request for reconsideration is as follows. Just a brief introduction by staff, and then the appellants will present their case in chief and any testimony or evidence in support of the appellant. And then for the county's case in chief, we'll go into a little more details on how we ultimately ended up with the decision of denial. And then any testimony or evidence in support of the county, that decision, and then the appellant will have a chance for rebuttal. So I will yield back to the board. Oh.
Okay.
Oh.
So
you to the board, yeah.
the county's case in chief, is that you again, or? Okay,
Well,
Yeah.
us, we're going to tag team it.
Yeah.
excellent. Okay, well, I guess, is that your brief introduction?
That's the
Yes.
brief introduction. Yep. Just sticking with
Okay.
the facts.
All right, then I guess we'll get started with, sorry, I'm going to probably butcher your name, Michelle. Michelle Fulham?
Close, full jump.
Full jump.
G's hard.
Okay.
Hi, good evening. I'm Michelle Fulgham. I'm a land use attorney. I've practiced here in Coeur d'Alene about 30 years. I
guess people can't seem to hear. I don't know if your microphone is on or.
It's on. I think
yeah,
you
the
just have
green
to-
light's coming on.
There,
Yeah,
that's better.
Okay.
Yeah.
There you go.
There's a little bit of an echo, so I'm kind of hearing double, but I'm a land use attorney here in Coeur d'Alene. I am familiar with the issues raised in the motion to reconsider. I previously was legal counsel for the Kootenai County Board of Commissioners. I had Pat's job about 25 years ago, representing Commissioners Panabaker and Compton and Rankin and Katie Brody. And I've done land use work for quite a while, and some of the cases that I'm going to cite to you as legal authorities regarding the motion for reconsideration in the air are actually my cases that went through district court and the Supreme Court that resulted in rulings that became the law of the land. The motion to reconsider legal authority, first and foremost, comes from your own Kootenai County Code. 8.8503 provides for reconsideration or appeal of decisions by the Board of County Commissioners. That stems from Idaho Code 67-6535-2B. And when there's non-compliance with the standards, reconsideration by the hearing body is appropriate before it goes to district court. This is essentially a do-over. It's a de novo review. You're not bound by the previous denials. You hear this case fresh and anew. And reconsideration is a way to correct errors before the matter gets pushed into district court, which is only fair. It's appropriate to have the board that made the decision reconsider and evaluate when there are allegations of errors made that need to be corrected. There are several deficiencies which render the previous denial of zone change invalid. The categories fall in due process violations, bias based upon a predetermined outcome, improper site visit, arbitrary, capricious, vague or ambiguous standards, failure to consider the evidence, and ex parte communications. Pursuant to Idaho Code 67-5279, subsection 3, reconsideration and reversal is warranted when you have any of those violations that I just mentioned. The first one that I want to start with is a due process violation based upon a predetermined outcome. And on page 4 of my legal memorandum that was submitted in support of the motion for reconsideration, I described the Ecrit versus Bonner County case. That was my case. I represented clients before the Board of County Commissioners in Bonner County, and Commissioner Bud Mueller announced that he was going to approve the variance regardless of what the evidence said, whatever the facts were, whatever the record was, we're going to approve this variance, and there's nothing that you're going to do that says the contrary. And he followed through. He voted to approve it, notwithstanding the evidence that it wasn't warranted. And the district court, it was Judge Stegner filling in, and the Idaho Supreme Court agreed a hearing body can't predetermine the outcome. You have to have a fair, unbiased, neutral decision maker, and that did not occur. And so the variance that was granted by the Bonner County Commissioners was reversed and overturned. Similarly, in this case, the county commissioner in the previous hearing announced, I'm not going to approve anything along Highway 97. I don't care if there's future development or not, I won't approve it. And those are quotes taken from the public hearing. That's a predetermined outcome. I'm not going to approve anything. I don't care if there's development, I don't care what those impacts. That's a demonstration that we are not dealing with a neutral, unbiased decision maker in a quasi-judicial proceeding, and pursuant to Ecrit and pursuant to Idaho Code, that demonstration of bias or a predetermined outcome is grounds for reversal. The next ground for reversal is also a due process violation, and that was failure to consider the evidence. Pursuant to the Idaho Code section I mentioned, 67-5279, subsection 3, failure to consider the evidence is also a basis to reverse. And in the prior proceeding, the commissioner stated on the record that part of the reason for the vote to deny was because I haven't heard anything different than I heard the first time. Well, there was new evidence. Sandy Young presented new evidence that the agricultural use was improper in the first place. She submitted assessor's records showing that this substantive evidence that it should never have been zoned agriculture in the first place. And that's grounds for reversal because there was new evidence, but yet in deciding to vote no, the commissioner said, I haven't heard any new evidence. And that's failure to consider the substantive evidence, and that's grounds for a reversal. On page 5 of the memorandum, I talk about unnoticed site visits. The Board of County Commissioners is obligated to avoid personal independent site visits. And the case I cite there, Noble versus Kootenai County, is a case where there was an improper site visit. My client, John Noble, had a subdivision application, and the commissioners, the Kootenai County commissioners, conducted a site visit, but they didn't allow the applicant, they didn't allow the opposition, they didn't allow the parties to be present with them. And the Idaho Supreme Court did a really good job in that case of analyzing, here's why we can't have unnoticed private site visits when you're making a land use decision. It needs to be a public notice site visit. Everyone needs to be there. You need to know what the commissioner's looking at, what they're observing, what they're relying upon, and if you don't do that in the public context that's providing notice to everyone, that's an improper site visit and it's grounds for reversal. In this case, the commissioner in the prior proceeding specifically as a basis for a vote to deny referenced their personal knowledge of the site, stating that they were familiar with the site, the property, and the road, and based upon their personal private knowledge of going to the site, observing the highway at the site, the commissioner was relying upon that personal knowledge, that private site visit, as the basis for denial. It's a little bit factually different, in all honesty, from the Noble case, because Noble, the Idaho Supreme Court said, yes, it was an illegal site visit, yes, it was improper, but it didn't actually cause the negative vote. It was no substantive harm. Contrarily, in this case, the commissioner in the former proceeding stated, because of that personal knowledge of the site visit, of the property, of the road, he was going to vote against it. His personal knowledge of the highway at the subject property caused his denial vote. So unlike Noble, we have an improper site visit. We don't know when, where, what condition it was when he went there and observed this, but he disclosed on the record that information from his personal knowledge of the highway caused the negative vote. So it is a substantive harm, and it would be grounds for reversal. The next Idaho code violation is zone changes or quasi-judicial proceedings. And while it's not as strict as evidentiary standards in court, it is relatively formal. And it's improper to rely on arbitrary, capricious, unreasonable standards. In this case, the deciding vote, because only 2 commissioners were present, so when the commissioner stated that he personally found the highway, whatever section, whatever portion, wherever he went, we don't know because it was an unnoticed site visit, because he found it atrocious and dangerous, he was voting against this application. Atrocious and dangerous are arbitrary, capricious, vague, unknown standards, and highways do have objective standards. It's measurable, there are calculations, there are ways to demonstrate, prove, calculate a dangerous highway. None of that occurred. None of that. That's not what the commissioner cited or relied to, but just said, based on my personal knowledge of having gone to this site, I find it atrocious and dangerous, and therefore I'm voting against it. And that's an arbitrary, vague, and ambiguous standard that's improper for a denial. That proceeding, only Commissioner Duncan and Commissioner Brooks were present, and so based upon the due process violations in that context, if you took away Commissioner Brooks' denial vote, there was no one else present, and so we only had Commissioner Duncan there, and the whose vote was not tainted or was not something that should be rejected, and so that wasn't sufficient for an approval. In the second hearing, only Commissioner Filios has a due process violation regarding his conduct because this application was filed in December of 2021. February and March, and this is in the staff report, there's work by the county getting feedback from the departments. In March of 2022, the highway district is providing input about the highway to the county. It's going in the staff report. It's very clear and obvious this case is moving through the county process. In March of 2022, Commissioner Filios had ex parte communications with representatives for the opposition. He, on March 24th, 2022, at 2:52 p.m., Commissioner Filios, on his official Kootenai County email, sent a petition to representatives for the opposition, Bev Twillman, suggesting that she and her group of neighbors along Highway 97 do a similar petition to the one he was attaching to his email and sending to oppose development along Highway 97. I have the email if you would like it, if you would like me to put it into the record. But clearly, it is improper ex parte conduct for the chair, the Board of County Commissioners, who's going to be sitting in judgment on this quasi-judicial zone change, to be having ex parte communications with the opposition saying, here's a suggestion, a petition that I've seen in other cases, you and your neighbors may want to try this, to oppose development along Highway 97. And he specifically says that, in reference to this petition that was circulated in Cougar Gulch, Bev, if you and the Route 97 neighbors are willing to do likewise, you can proceed on the basis of lack of adequate infrastructure, specifically the essentially unpremitigated condition of Route 97. Let me know if you would like help. And then he's forwarded the petition on. This is why our case is pending. It's ripe, it's been filed with the county, and it's coming before the very same board that he's going to make a ruling on. And he did. He voted against it. So for those grounds, we filed our motion to reconsider. The denial should be set aside and reversed, and the zone change should be granted. I'll let Sandy Young address the substance of the zone change, but I'll stand for any questions that you have regarding the basis for reversal or the legal standards.
Questions?
I don't have any questions.
Okay, questions, Bill? I would like the email.
Yeah, I would like to take a look at that too.
Which exhibit should I mark it, Amy?
Exhibit one, B 1001.
Yes, please. Thank you.
Thank you.
Okay.
Good evening, Commissioners. Sandy Young, 3906 North Schreiber Way. I'm representing Vertus. We are the land use planners that are representing Pines Partners. I have been in private practice for about 16 years, and before that worked for the county for 10 years as a planner 3. So have experience with lots of zone changes. And the few things I want to point out are what a zone change is and what a zone change isn't. I know that 2 of the commissioners have heard these facts. I'm sure, Commissioner Matari, you've read through the staff reports and the HE report. But for the record, I would just like to touch on a few facts about this case. So we know that a zone change is simply a zone change, that we don't take future applications into consideration when we decide on a zone change. Those will stand on their own merit, whatever they are. It could be a conditional use permit for a nudist colony. Can't talk about that tonight. We're just going to talk about the zone change and if it's appropriate. And as a planner, I would say it's appropriate for several reasons, but then I'll use the HE's and staff's comments to back that up. So approximately 50 acres, almost 50 acres, zoned ag. It's an island of ag surrounded by rural with restricted residential also around it. We know that rural and ag have a minimum parcel size of 5 acres. Restricted residential kind of flips that and says you can have 5 homes per acre, roughly. So this applicant could have asked for restricted residential and been within reasonable rights, but he chooses rural because ultimately his intent is 3 residences on 50 acres. He has a home there now, he and his wife. So existing single-family residence, 2 more are planned. Those are the plans for now. There was some talk about other development permits in the past, but none of that has come to fruition. We're not working on it, so it's not in the works. So simply a zone change from ag to rural to allow him to submit a minor subdivision application to the county. The parcel sizes will likely be 3 5s and then a 35 acre parcel. They'll be standalone, no public services, so individual septic, drain field, well for water, so no connections of any kind. And that's part of the compliance with the country designation in the comp plan. It's that you're not putting an undue burden on public services. This parcel does there's ingress directly onto Gaza Road, a public road, not onto Highway 97, and you can go 2 ways when you come out of this. You can go north to Burma Road, or you can go south to Highway 97. So that just kind of gives you an idea of the area. The zoning ordinance has certain criteria that you must meet in order to prove out your zone change, and those are included in my memo that's in your packet. I could read through those, but if you'd like me to, I certainly can, but I know you've got that information. And one of them that pops right into my head is that how have conditions changed out there since 1973 when the zoning ordinance was first established? So interestingly, we found that 3 miles as the crow flies, you don't run into one more ag zoned parcel. This is the only one on the east side of the lake. The next one you come to is down near the chain lakes. So we have this island in a sea of rural and restricted residential, and yet it's never been used for ag purposes. We don't know why in 1973 that designation was put there. I went back in the assessor's records, which I did present at the board hearing, and found that they have never even had an ag exemption due to the fact that the soils there are so poor. It's very shallow bedrock, and the most you could hope for is a timber exemption on a portion of it. I was fortunate enough to actually be the land use planner for Gosser and working for the county when it came in. So I was fortunate enough to drive that site on ATVs at that time, 4-wheelers, and actually see all of Gosser Ranch, which sits adjacent to this. And to be clear, I do want to emphasize this is not a Gosser Ranch project. They happen to sit adjacent to it. That's it. There are no plans in the works for it to become Gosser. I want to be very clear on the record about that. So I got to drive it and actually see the fact that it was used for some cattle grazing in the past, but not enough for it to really be productive land. So we have home sites going in, and what the hearing examiner told us is that There has been compelling evidence to show that the parcel is not suitable for ag uses. It's unclear, he stated, whether it's ever been used for ag purposes. It's impractical zoning, these are all his terms, and that rural zoning will preserve and protect, yet still promote some reasonable development. And certainly 3 homes on 50 acres can't even compare to what it's surrounded by. And I'm not just talking about Gaza Ranch, but all of those homes along the lake that sit on parcels that are much less than an acre in size. He also found that this request is compatible with uses in the area, that there will be no harm to adjoining properties, and it won't materially be detrimental to the public. Most importantly, it's consistent with the comp plan. It's a country designation, and country says we want to see rural home sites, but we want to see them developed, and we want to see them developed in a manner that is consistent with the word country. The Kellners have actually come forward and said, we propose wildlife corridors on our 50 acres. That's what the county wanted to see when the time comes to submit a subdivision application. We're willing to do that. Staff was in support of this originally in their staff report. Every public agency that was contacted had no concerns with it. Not fire, not highway, not Panhandle Health. There was absolutely no area of concern that was brought to light as we were going through the process. Then, of course, when we got the hearing examiner's report and we were told that, yes, they agreed with staff, but then he added on, beefed it up even more because of the testimony that had been presented at the HE level. Then he listed 11 different reasons under his conclusions of law on why he supports this. And I'm going to read those briefly, and then I will stop and entertain questions. Number 1, the applicant has demonstrated sufficient justification for the proposed change. Number 2, the proposed change is generally consistent with the land use designation in the comp plan that applies to property, which is the subject of the application. That this proposed zone change is generally compatible with the present and reasonably expected future land uses within the vicinity. It is supported by adequate public infrastructure. It will not have a material adverse effect on the delivery of services. It will not materially adversely affect the value, character, or use or enjoyment of neighboring properties. Number 7, the denial would have a materially adverse effect on the use and enjoyment of the property, which is the subject of the application. It's not in conflict with the comp plan. It's suitable for the proposed zoning. It will not be detrimental or endanger public health, safety, or general welfare. And lastly, it will not result in undue traffic congestion or traffic hazards. So with that kind of support, I feel, Michelle feels that, and of course the applicant, that this application wasn't given a fair shake with a quorum not present, and also for the other reasons that she mentioned.
Okay. Questions? Ms. Young?
I'd be curious, from my understanding there, you said that there'd be 3 5-acre parcels that would hold a home on each parcel. And then the 35-acre parcel would be a golf course.
No, originally we had proposed that as a potential use, but the applicant has not moved forward with that. If it did happen, they would have to present a conditional use permit to the county, and then that could be approved or denied based on whatever the merits of that application are.
Okay, because I looked in the paperwork and it
And you
said,
saw that, yes.
It said that that the fourth lot would be reserved for a private golf course. So what does that mean now as far as an intention for that 35-acre lot?
So the intention at this time is not to put a residence there, but to keep that as open space to enhance the 3 homes that will be there. So the one that's there now, and then the other 2. So again, that would have to come forward in an application to the county to be presented, to be again judged on its own merits. And honestly, and maybe David or Pat want to speak to this, or Amy, if we did come forward, let's just say it was a, trying to think what another CUP, a shooting range in the rural zone, which is also allowed in the ag zone. It could happen. Is nothing to say that that can't come forward, but that again would have, you would eventually hear it and it would be judged on its own merits.
Yeah. And you said right now there's no plans for any additional development outside of these 3 residential
That is
lots?
correct.
Okay. Is there anything that could change that? Let's just say that the zoning was changed, and as soon as it was changed, plans could be developed for
Any-
10 5-acre lots. So what was presented here is just an idea, not necessarily anything that the owner is saying, I'm willing to be bound by.
That is correct. And the only reason that I brought that up at the first hearings is because in my experience, right or wrong, previous boards always want to know, because when there's a big unknown, everybody has questions. So at that time, that was a thought that the applicant had, but now here we are 18 months later and we've got a market that's very different than it was when we were here before.
Yeah.
So what they're telling me at this time is that we know we want to submit that minor subdivision application, and we
Yeah.
are thinking about creating those lots even for our children. So we at least have that under our belt, and then we can move forward from there.
Yeah, and what I see is that the Highway District reviewed this as well, and it was under the auspices of just a limited, it says subdivision limited to 4 lots. So everyone's looking at this saying, this looks fine based upon this,
Yes.
yet
And I don't
the
want to,
very day after, if it gets changed, the zoning, we could say, we now have new.
26 lots.
Yeah.
And we got to, and I'll tell you what, I'm not going to be standing here at the podium presenting that one, because they could. They could submit to the county and say, we want a major subdivision, and we want to develop it with 3-acre lots and have a conservation design subdivision. That a zone change does open the door to that. And you have a tool that's available to you that I'm not sure if it's been brought to your attention, but back in the day, we used to do the conditional zoning development agreements, because that's what the board
Yes.
liked to see.
And I happened to look at the statute for that, and I want to ask Pat about that too. And I don't know if I should ask later, or if I can ask that now.
I would hold that question.
Okay. Okay.
And the only reason we don't submit those anymore as planners and attorneys is that the county's taken a different direction on that and said the boards, this board, maybe previous boards for sure, not as keen on those. So we don't come forward. We're not opposed to that.
Okay.
So just so you know that.
Okay, well, that's good, because, sadly, it's kind of like when you sign an auto contract to purchase. It says, whatever the salesperson told you, if it's not in this contract, you cannot hold the dealership to those statements. And I read this application, and I thought it was really nice, the idea of a golf course and 3 nice residential homes. It's a very nice part of the county, so.
And that golf course, the intention originally, and when they did have that as a thought, was that it would be private for those.
Yeah.
Just small enough, could barely hold 9 holes, and it would be for those homes.
Like a little par 3, so.
A little par 3,
Yeah,
yes.
okay. Well, those are my questions.
Okay. Bill, how about you?
None.
None? Okay,
Thank you.
thank you. All right, so I think it would be our side and then the
Well, actually,
public's.
if there's anyone that wants to testify in support of the appellant's position, they would go next.
Yes, is there anyone? I don't have any sheets for them, Pat, so
Oh, okay.
there's, yeah. All right, nobody is going to testify in favor of the appellant, apparently. No members of the public. So,
Would anyone on Zoom possibly?
I'm looking. There's one individual that's not staff. Jamie Keller, did you?
Oh, it's Kellner's. It is the Kellners.
okay.
Do you have a question for us? We'll be happy to answer it.
I don't think there's any question, but if you wanted to take your 3 minutes in order to testify in support of this application, you may do so now.
The only thing my wife and I would say is that we thought the 50-plus acres with 3 households on it was appropriate use of the land. I am an avid golfer. I love to play golf. A dream would be to have a 9-hole short course on the other part of the parcel. It's a long way away from a reality. And we just want to move on with our lives. We've been at this quite a while now. And hopefully everybody will see that this is a good use of this property. Our neighbors are in support of this. The Ostrowskis have written an email stating they're our direct neighbor. They own 3 parcels next to us. We've given them a total understanding of our plans from the very beginning, and they were supportive and have communicated that to the board. So we hope the rest of you see that this is a valid and respectful use of this property. Thank you.
All right, thank you very much. So now we'll head to the county's presentation.
All right, and we're gonna tag team.
Yeah, I'll go ahead.
You wanna
and just
start?
Reserve 10 minutes at the end,
Okay,
and then, so go for it.
okay. And I'm just gonna skip over some slides. I just made them in case you wanted to review the original decision. I can do that still, but if you want me to just dive right into our case.
I don't need to review the decision. No.
Okay, all right, well, I will go over those real quick. Okay, for this case, as I stated in the introduction, the decision was made on a non-consensus, ultimately resulting in a denial. Therefore, for this case in chief, we're just gonna go over the whole history of what happened, and we're gonna go over the public agencies, public comment, the recommendations, and then the major discussion points the board made during deliberations. Just gonna go through that. So the public agencies that were included in the review are listed here. It's typical of agencies when they don't have a specific use or density to give us no concern, or to state that they will provide more specific comments when they have a proposal before them. And that is what we saw in this case. And then for public comment, that's just a brief summary of the comments that we received. And then I compiled them here in this slide. So the public expressed concerns for the zone change for lack of infrastructure, increased traffic on both Highway 97, Gaza Road, water and sewer availability, conflict with the comprehensive plan, concerns for the golf course, impact on the area, specifically the neighborhood and wildlife, were the majority of the concern, evacuation concerns in event of emergency, nuisance, and potential for a major subdivision and increased density. For the staff analysis, as the appellant described, the staff during the first hearing in front of the hearing examiner did recommend approval. We found that the applicant had met all application requirements. It was compatible with the surrounding zoning, since rural zoning is to the south of this parcel. It is consistent with the comp plan. It was not considered spot zoning. It is the only agriculturally zoned parcel on on the east side of the lake and on this particular peninsula. Agriculture and rural zones allow for similar uses, and I'll have some land use tables for that. The major difference, of course, between rural and ag is that the agricultural zone prohibits subdivision. And then there was a little trivia there that it had been restricted residential for a very brief amount of time when the county first had zoning in 1973. And then the owner at that time had it changed back to agricultural. I don't believe there was really, I don't remember the reason either. The staff analysis, when we have an actual application for any subdivision or conditional use permit, the Highway District and Idaho Transportation Department will likely request the applicant to provide traffic data. And the county will ask for data for water and sewer, and Panhandle Health will also comment on that. For specific uses such as a subdivision and conditional use permits, we can apply conditions of approval. We cannot provide conditions for a zone change. But conditions that the county will likely impose would be infrastructure improvements, and then of course any site disturbance to mitigate stormwater and erosion. And I wanted to just briefly go over the land use tables just to show you how many uses these two zones have in common. I find it pretty useful. As far as the agricultural uses on the right side, you can see that there's more intensive agricultural uses allowed in the agricultural zone as opposed to the rural. And then I also wanted to point out that golf courses are allowed in both zones through a conditional use permit. But then I also want to say that there are some differences. The rural does allow for uses that are not allowed in agricultural. So I just wanted to point that as just facts. When it came to the hearing examiner recommendation, they had recommended approval as well. They found that the current designation was inappropriate. The applicant chose to propose rural instead of restricted residential, which is a higher density zone. They found it's compatible with present and expected uses, supported by adequate infrastructure, and they did find it was consistent with the comprehensive plan. At the first hearing before the board, when the motion to approve the request was brought forward, Commissioner Brooks had voted nay for concerns for increased traffic on Highway 97. And these are just a summary. Commissioner Duncan voted aye for agreement with the hearing examiner analysis, stating that it's difficult to comment on specific uses when there's not a separate application or findings brought forward. The rural zone allows for a lower density than restricted residential, and the agricultural zone does allow for more intense agricultural uses, which would be detrimental to the surrounding area. The former commissioner and chairman at that time voted nay for concerns over water availability, traffic on Highway 97, that large-scale development or the potential of it was not appropriate for the area, and also felt that while this is just a zone change, that future uses still must be considered. Now, here's where we get into why was a second hearing took place for a zone change. It's because it's a material change. Essentially, when the board disagrees with the hearing examiner's recommendation, which was a recommendation of approval, it's a material change, and per our code, we have to hold a second hearing. So that's why the second hearing took place in this case. And that's where we had the non-consensus. Chairman Filios was absent for that hearing. Commissioner Brooks and Commissioner Duncan had the same, discussion, and their minds were not changed. And so it did result in a denial. In the order of decisions, the board could not come to a consensus on the following findings. Specifically, that adequate public infrastructure was not supported, and that the proposed change would cause undue traffic and traffic hazards. So I stand for any questions you have, but that is basically a summary of what took place. Oh, and then Pat was gonna.
Okay, first of all, do you have any questions for Ms. Hillen on her presentation? David, did you want to?
No,
say?
I think
Okay.
everything's gone the way it should so far.
Okay, for the record, I'm Pat Braden. I'm Civil Deputy Prosecuting Attorney for the county. And Ms. Fulgham was one of my predecessors at one time. I actually worked on the Ekrit case that she cited as a law clerk for one of our district judges at that time. So I'm pretty familiar with that case, both in that capacity and as a land use attorney myself. And I want to turn to that case to discuss some of the things Ms. Fulgham brought up in her argument. First of all, the remedy that that the Idaho Supreme Court prescribed for a viewing of property that was unrelated to the matter in question would be to disclose the fact of the view prior to the hearing to allow parties to object or move for a viewing by all the commissioners. In this case, it had not been disclosed until the end of the last hearing, but you know it is out in front of the board for everybody to discuss. And one of the options in this case could be to schedule a proper site visit. I don't think that it's not absolutely necessary, but that is one option if the board were to choose that. Another thing I would mention on that is it's specific. The Supreme Court specifically dealt with the situation where the commissioner in question had actually viewed the property. I'm not sure that's the case here. My recollection is that Commissioner Brooks talked about driving highways 97 in the vicinity of the property, but did not view the property itself, and perhaps that can be clarified during deliberations. Earlier in that decision, the Idaho Supreme Court made the distinction between just taking a position in public on a policy issue related to an application that comes forward before them later. The direct quote there is, "A decision maker is not disqualified simply because he has taken a position, even in public, on a policy issue related to the dispute in the absence of a showing that the decision maker is not capable of judging a particular controversy fairly on the basis of its own circumstances. Pre-hearing statements by a decision maker are not fatal to the validity of a zoning determination as long as the statement does not preclude the finding that the decision maker maintain an open mind and continue to listen to all the evidence presented before making the final decision." By way of explanation then, pre-hearing statements by a decision maker are fatal to the validity of the zoning determination if the statements show that the decision maker has made up his or her mind regarding the facts and will not listen to the evidence with an open mind, or B, will not apply the existing law, or C, has already made up his or her mind regarding the outcome of the hearing. So basically, as long as each of you can honestly say that you have an open mind, you will listen to the evidence and consider the evidence in the record before making a final decision, and can judge the controversy fairly in a disinterested, neutral manner on the basis of the facts and the law that apply in that particular case, then you're okay. It's basically when you're biased or prejudiced in favor or against a certain party or position that becomes legally problematic. So I've dealt with both the the mind made up issue, the not considering evidence issue, the site visit issue, and my purpose in reading these quotes in their entirety, and by the way, that's Ekrit versus Bonner County, 139 Idaho 780, at pages 785 to 86, and 86 Pacific 3rd, 494 at pages 499 and 500, for the record. But basically, it's a question of bias or prejudice. And the reason for reading these verbatim from the opinion is in part to caution and admonish each of the commissioners to make sure you have an open mind, you are considering the evidence in the record, you are considering all the criteria, I think it's 11 criteria, for determining whether to approve or deny a zone change. It is 11. And that you will make your decision fairly based on the facts and the law. And that's all the law asks. So I would ask you to frame your deliberations on this reconsideration in this manner. One thing that was brought up by Ms. Young, which may be an option for you to consider in making a determination, is you could, if you think a conditional zoning development agreement might be something that might help in your decision on the zone change, you could vote to remand the matter to the hearing examiner and staff for consideration of the zone change with a conditional zoning development agreement, which would limit the development on the property and would eliminate the applicant's ability to say, whoops, changed my mind, got my zone changed, and now I'm going to do this. And that can allow for subdivision, future subdivision. It could limit it to a minor versus a major if that's what is agreed to. It could identify uses that the applicant may want to apply for a conditional use permit in the future, with the understanding that that would stand on its own, that the board could approve or deny that permit application at the time it's brought. So that's so that is an option that you have in front of you if you wish to consider it. But other than that, just consider the 11 criteria for amendments to the official zoning map versus the facts that are in the record and the testimony you've heard at all three of these hearings, and make a fair and partial decision. That's all I have.
Okay. Any questions for Pat?
Yes, I just want to confirm, because I looked at the Idaho statute 67-6511A, and it says that you can require or permit as a condition of rezoning that an owner or developer make a written commitment concerning the use or development of the subject parcel. So that can include
That is correct.
the lots and so forth.
Yes.
Okay.
Yeah, and as Ms. Young mentioned, we have done that several times in the past. So.
Okay. Okay. That's my only question.
Okay.
All right, anything for Pat? All right, so it looks like we will now,
Testimony or evidence in support of the denial, and then, of course, Ms. Fulgham and Ms. Young have their
Have the
chance for
rebuttal. Yes. Okay, Bev Twillman, opposed, wishes to speak?
Thank you.
Exhibit B 1002.
First off, I would like to officially welcome Commissioner Matari. This is the first time I've appeared before him. I'm not sure how many hearings you've been at, but the people on the east side of the lake are pretty concerned about their future and about their land and their community. I would hope, I didn't realize it was something that would jeopardize decision-making if you visited the east side of the lake just to see the community. I think that's very important wherever you're making decisions, that you have some kind of a knowledge of the infrastructure leading in and out, of the community in general, of the views of the people. And it's impossible in this diverse community for any of you to know everything there is to know about every community. But the least you could do is to drive that road, especially since it comes up so often. You will hear, and Commissioner Duncan and Commissioner Brooks have heard enough about Highway 97. They're probably sick of it, but it's only getting worse. So that is one of our main concerns. It's our only way in and out. So I hope that you've driven it. If you haven't, I don't think I'm going to be off base by inviting you to come up. I mean, I won't meet you. I won't even tell you where to go. Just drive it. I would ask that of any of you. So and I'm sorry that Commissioner Brooks got in trouble for driving it, but I said the same thing to him. Drive it, and he did.
I drove it a long time before this came up.
Yes, that's true. And I know Commissioner Duncan, she drove it. When she came out, there was a complaint about something else totally unrelated. She drove it. So she's been out there. But if you haven't been out there recently, it's only getting worse. And we go to the Idaho Department of Transportation and we are told, we can't do anything. As long as your decision makers are giving permission to have different things happening in growth, our hands are tied. Well, you guys are the decision makers, and so that's why we come begging to you to see the reality of the damage that this community is suffering. It's not so much the traffic of the people who are in these areas and living there, it's the damage from the construction vehicles that are brought out there. The pictures I have given you are for you to see that what we deal with on a day-to-day basis. Overweight, over-length vehicles that get these special permits at 3:30 on a Friday afternoon when traffic is trying to get home, and they keep lines of vehicles. It's amazing, and I only caught a portion of it because I happened to be behind it. Now, the Kellner family knew what the zoning was when they bought this land. And if it's changed from agricultural to rural, subdivisions will be allowed. It states in the hearing examiner's report, it's right there in black and white that they intend to put in a golf course. Well, maybe they've changed their mind, but they could change their mind and put in a lot more homes too if this zoning is changed, which means more traffic for us as well.
Sorry.
That time went fast, but
Thank you, Ms.
thank
Tolman.
you.
Yes.
If you have any questions,
Nope.
Mr.
No
Matari?
questions. Thank you, though. Thank you.
All right, Barbara Durrell. Opposed, wishes to speak.
Barbara Durrell, 7153 South Eddyville Road. We've lived out there since April of 1977. Got a story to tell you. Johnny Gosser had all of his cows running on that land up there. That's why it's agricultural. And we planted a row of corn out there, and we came home from work, 16 head of cattle from Johnny's place, come down, ate all our corn. It was all ready to be picked. So the ranch up above me and the horse farm right to my left, we got together, we put in a herd law out there. It still exists. We have a herd law. Now, I want to tell you who lives out there. There are two groups of people that live on that east side of the lake. One are the lowlanders. They're the ones that have all the summer homes along the lake. Most of them are not full-time people. They're summer people. Great, we love it. Uplanders, that's the rest of us. We live on rural land. There's one house plus acreages. Most of us have cows, horses, pigs, chickens, all sorts of stuff. It's rural out here where we live. And the reason I'm telling you all this is that the Kellners built a house with acreage. That's exactly what is out on the east side of the lake. One house on a bunch of acres. And so there's absolutely no reason to change the way it is. I love Julie. I know her. And I feel really bad sometimes about what's going on. But they have a paradise up there. And We just want it to stay a paradise. Yes, it is agricultural land. Cows can run it. Lots of people have their agricultural exemptions for tree farms out there. The land that they are using for hay farms, it's all into agricultural for trees. So that's what our area is like out there. It's for us rural farmers. I have an orchard. I run an organic produce stand on Eddyville Road. 36 trees in an orchard, plus a market garden that I run. It is agricultural out there. And the road, Lord bless us, it's falling apart. It's got so many holes in it. Sides of the road are down and falling off on the side of the road. And the state will not fix the road. God bless you for your statement, Mr. Brooks, because that road cannot take any more construction. So I know I've only got 28 minutes or seconds left. Do you have any questions? Could you come out and see what that road is like? Go together, come with some of us, let us show you what's happening out there. There's a din. 6 o'clock in the morning, you hear a roar start. It goes on till 7 o'clock at night, and they're pounding on the basalt with pounder things to break up the basalt. You can't live out there. It's so bad. Bless you. And I hope that you think about us out here, because we've been out here a long time, and we pay taxes also.
Thank you, Mom.
Thank
Okay.
you.
Thank you.
Deborah Stone, opposed, wishes to speak?
Deborah Stone, 5321 South Freedom Lane, Harrison, Idaho. In response to the comments by the attorney, Mr. Brooks did not make an unauthorized site inspection, nor did he have predetermination at the September 8th hearing. He'd already determined at the July 14th hearing that he was opposed to this. Because he made comments about the condition of Highway 97, that's hardly arbitrary and capricious. That's based on facts. He didn't perform an unnoticed site visit because he didn't visit the site. The site's on Gaza Road, not on Highway 97. I also would like to point out that the initial request by the applicant was for 3 rural lots and a golf course. So it changed today, it could change tomorrow. The applicant knew, or should have known, the zone designation and the restrictions when the property was purchased. It's their responsibility. The rural residential development and golf course plan does not meet the objectives of the county comprehensive plan. It will not foster a rural community character by encouraging open space and public, I repeat, public resources. A private golf course, which was planned initially, will not serve local residents. Adequate public corridors are not and will not be available. East Side Highway District has nothing to do with Highway 97. That is totally under the auspice of ITD. There is not adequate infrastructure, and there is questionable waste disposal. The zone change will not meet the requirements of the County Land Use and Development Code, which requires standards for an orderly growth and development, and to avoid undue concentration of population and overcrowding of land. The road is in miserable shape. There's also a question of water. The county comprehensive plan mandates that there be adequate water. There was just an article in the paper. Lake Coeur d'Alene is at 46% of its normal storage. The Coeur d'Alene St. Joe Basin has only 38% of its normal precipitation. Where is the water coming from for this? There's no plan. I would request that you deny the zone change application.
Any questions?
No questions, thank you.
Thank you. Carleen Cada, opposed, wishes to speak?
Carleen Cada, 20621 South Highway 97, Harrison, Idaho. I'm reading this for Jill Moncrief. She writes, when voting on a rezone issue, the Board of County Commissioners should be required to actually visit the site they are making the final decision on. They aren't, and I ask, why not? Kootenai County is one of the most diverse counties in the state. A flat, two-dimensional land plat may have swirls indicating topography, and the opposition may paint a dire picture of what it looks like. But there is nothing like visiting the site, walking on it, or at least driving to it to get a feel for the surroundings. The homes, the wildlife, the forest or woods, excuse me, the beauty of the area, maybe trying to envision what the proposed use would look like, how it would affect the ecosystem, the neighbors, the community. It's like choosing to tear down a beautiful building in a beautiful setting in order to erect a strip mall without visiting the site. The planning department has a statement on their website. Community development is dedicated to responsible land use planning in an effort to guide growth and prepare for a healthy future. Since 1973, the county has used zoning and land use regulations to ensure that development contributes to the well-being of residents, neighborhoods, and our shared community. The mission statement of Kootenai County states, "It is the mission of Kootenai County government to provide professional service with regard to public safety, essential service, preservation of natural resources, and the responsible management of public assets for the common well-being of our citizens. Allowing more natural land to be developed and have private golf courses built, which is stated plan for this parcel, does not contribute to the well-being of residents, neighborhoods, and our shared community, let alone what it does to wildlife, the increased traffic, water pollution, the drain of natural resources, and the strain on limited infrastructure in the rural area." And she thanks you.
Thank you. Okay, Thomas Little opposed. Do you wish to speak? Okay.
Thomas Little, 1427 Gotham Bay Road, Harrison, Idaho, 83833. My family, we have lived at Gotham Bay for 45 plus years. So you could actually consider my family as experts on Highway 97. So we've seen everything, we know. And we could tell you from a long time ago how it used to be and how it is now. The traffic, that's my main reason I'm here. The traffic on Highway 97 has gotten so very bad that it's almost costing us our lives, seriously. So what's more important? The safety of the residents that live there that try to go to town. The safety is the number one thing. My wife and I were coming home not that long ago along the Flying Arrow Ranch. There's a passing zone there, and the passing zone is heading to the north, I think, a single lane, so you have to come into the oncoming traffic to pass. My wife and I were coming home. We were heading south. This pickup truck was passing a vehicle. It almost killed us. We were almost in a head-on accident, and I had to stop. We were so upset. I called the ISP. I registered a complaint about the vehicle. This is not the only time this has happened. The double yellow line that's out there right now, every blind corner, every intersection, there's a vehicle passing you over the double yellow line, and people are going to get killed. This is very serious. It shouldn't be about what these people want over here. Not at all. It's about people's safety and their lives. My family has lived here for a very long time, and you can hear in my voice I'm not happy. Now comes to the other part, construction vehicles. I have a CDL, which means I can operate about every vehicle on the road, truck, whatever, you name it. I've hauled them, I've done it. I have a CDL, I've never had an accident, I've never had a ticket. So I know how to operate trucks, believe me. So I have been forced off the road, off Highway 97, 5 times by dump trucks that are coming around the corners in your lane. So I actually called ISP and asked them about this issue. They told me that it's a gray area. It's a gray area. So what do? Do you just sit there and let these dump trucks run over you? Or do you force your vehicle off the road? I've done it 5 times. I live on Gotham Bay Road. At the very bottom to the south, it's a blind corner. One day I was turning right to the north to go to town. And all of a sudden I look in the mirror and this dump truck is about ready to run over my pickup. So all of a sudden I gassed it and got out of his way. And I pulled over and I went like this to the guy, hey, we need to talk a minute. And he locked up his brakes. He almost killed me. And the top of Gotham Bay Road, go up there, take a look. To the left on Burma Road, if you look on Burma Road to the left, so I guess that would be north, and then right to the south. Either direction, you cannot turn and see oncoming traffic. It's terrible. And
Thank you, sir. I appreciate it.
Sorry.
Thank you.
All right. Norb Twillman, opposed, does not wish to speak? Correct. Okay. And Mira Riga? Oh, I'm sorry. Myra Riga, opposed, does not wish to speak. All right. Is there anybody else who did not fill out a form who does wish to speak in favor of the county decision? Okay. Then I think we are ready for the rebuttal. So, Ms. Fulgham or Ms. Young? Yes.
Thank you. Briefly, the course and scope of these proceedings are a zone change. And the zone change is altering the coloring of this property on the map. It's not creating traffic or development or some of these other things, which are legitimate concerns. I mean, we have to deal with traffic. We have to deal with safety. We have to deal with those things. But that's not a basis. It's not a criteria. It's not a grounds to change zoning when this application meets all of the zoning requirements. Now, a development agreement saying 3 residences on 5 acres and the 35 acres of open space, great. Fantastic idea. Fantastic idea. It really limits what can happen there. Like Sandy Young said, we used to do it all the time at the county conditional zoning, and then you have that contractual assurance because those development agreements are recorded against the land. They're binding against the property, and if you sell it, it rides with the land on your chain of title. So that's a great way to do it, to assure that you're comfortable it's only those 3 residences. But and I agree, you know, Pat Braden and I, we've read the same cases, we see them the same way. We're here to cure those deficiencies that occurred. If you wanted to do a site visit, there's ways to do that. There's ways to publish it. There's ways to go to the property. I think it's a little bit disconnected to what the majority of the comments are, which is regarding not Mr. Kellner and the Pines Partners property for the zone change, but they want you to look at the road, which really isn't the site that's in the application. So I'm not really sure. Clearly something needs to be done. Clearly safety and concerns need to occur. But when a landowner qualifies for a zone change, he meets all of the criteria. He's been recommended for approval by the hearing examiner, by staff, and the evidence in the record is this fits the legal standards, then it's prejudicial and it's unfair to deny the landowner the zone change that he's legally entitled to, that he's legally qualified for because of other factors outside his control, which is the highway. And he can't, that's not his property. He can't do anything about it. He's legally entitled to the zone change. He qualifies for it. That's not to say there aren't valid concerns about the highway, but they need to be remedied and dealt with in the context of dealing with the highway and those government entities, not punishing a property rights owner who's legally entitled to the zone change and qualifies for them. It's not that we don't take those concerns seriously, we do. It's just not grounds to deny a zone change or punish the landowner who's got property rights in his land. I did want to mention, as Mr. Kellner did, his neighbor who owns 3 parcels next to him, and I'm right there with you, Chairman Duncan, on the names. Uzowski. I'm terrible on that name every single time. But this is the person who's right next door to the property, really going to be impacted more than anyone else by it turning into 3 residences and the 35 acres, whatever, open space golf course, who knows? And he's in favor of it. He's written the letter, it's in the record, and he's in favor of it. So I think that weighs also, in addition to the criteria you've heard, in favor of approval of the zone change.
Okay.
Do you have questions?
Any questions?
I have one question.
Yes, sir.
Since the golf course does not appear to be something that's in the future with the landowner, based
It
upon...
would be a separate proceeding. We'd have a whole new public hearing. You'd have a conditional use permit application. Once you applied for that application, then it would be vetted, and if you found that the golf course is not appropriate for a CUP, you vote it down.
I'm just curious if the landowner would even consider just the 3 residential properties at 16 2/3 acres, if he's not going to pursue developing the land for a golf course.
Yeah, the way you can do development agreements is instruct council, here's what we'd request to be negotiated into the contract, and then there's essentially a negotiation, and those terms are agreed to, or they aren't. I'm not the land use planner, so I don't really know that, but I think under the statute, you can vote to approve the zone change subject to the development agreement getting resolved
without being specific about the uses, but there is a development agreement that then comes forward.
You probably need to come to the, sorry.
Sorry, I'll let her deal with
Okay.
that. I'm not trying to avoid it.
No.
And Pat and David can clarify this if they wish, but I think that in the majority of cases, to just say that a conditional zoning development agreement be drafted, and if you're comfortable with saying it's a minor subdivision, we don't even state the acreage. Minor means it can't be any more than 4, because it could be they'll want to do 6 so somebody can get a timber exemption, and no one will ever care other than the owner. So I think being more broad like that, knowing, as Michelle had stated, there will be another bite at the apple, and that if you think of it in these terms, as I always have, right now that property owner is pretty free to not develop it, but do the things they want to do on that property. Whereas when you start putting conditional use or any kind of development permit, now all of a sudden they've got a site disturbance ordinance. If you disturb more than an acre on that particular parcel, now the EPA's involved. You've got to do a construction general permit with them. So everything's a big deal and everything becomes scrutinized. It's almost to the benefit of the county when somebody does come forward with something like this, because now you have all the latitude you want to put all the conditions that you want on that approval. But generally, zone changes are broad. You don't want to get too much in the weeds by saying, well, you can do this, but you can't do that. And Pat and David, please elaborate on that if you feel that you need to. And we can certainly, you're able to look at those that have been approved in the past and know. Of course, we'd prefer a decision tonight so that you're just making a decision, knowing it's going to come back to you. It'll go to the HE and then it will come to you.
So I guess that's my question. If we approve it, it still has to go through the HE again if there's a conditional zoning agreement?
No, not for a conditional zoning development agreement, but go ahead.
Seth?
I thought we would remand it back.
Her point was it would need to go back to the hearing examiner for CZDA, and that's not the case for CZDA. it would be the case for a CUP.
Right, yes, right.
Excuse me, I thought it would have to go back.
Yeah, actually, it would go back to the hearing examiner.
Yeah.
For recommendation.
For this case.
Because it would be because it
Okay,
would
that's
be.
where I was confused.
Yeah, I mean, it wouldn't kill the case, so it would keep this case going, but would go back to the hearing examiner for consideration of the agreement, the development agreement that's been negotiated between the property owner and the representatives in community development. And for a recommendation and ultimately back to the board to determine whether it should be approved.
Okay. All right, any other questions?
No, that's the way I understood it, was that you said that it would be remanded
Right.
back to the hearing
That
examiner
is one of the options that is.
for the conditional zoning development agreement.
All right, any questions, Bill? All right, I would entertain a motion to end public testimony and enter into deliberations.
I move that we end public testimony and enter into deliberations.
I second the motion.
Roll call.
Roll call.
Bill Brooks,
Aye.
Commissioner Matari,
Aye.
Chair Duncan.
Aye. All right, so now we are in deliberations, and Bill, did you want to go first?
Nothing I heard changes my mind.
Okay. Bruce?
Yes, I'm open to the idea of the conditional zoning development agreement for a maximum of 3 residences. I think that right now we're in a situation where with a 50-acre lot and an owner who's willing to limit the amount of growth, that this is our time, our opportunity to make that a permanent situation and not risk in the future the property being sold, a different board, what have you, where that could be changed and a 50-unit development could occur, or 25 or something like that.
Okay. So this is just a zone change. They could have asked for restricted residential, but they did not. They asked for rural. So the max that they could apply for a major subdivision, which would be 10 residents on that parcel. And any of the other uses that have been discussed, the golf course or whatnot, would require a conditional use permit. So all of that would trigger the whole process, come back before us, and we would rule on that. Tonight, we're just ruling on the zone change only. And based on that, the criteria has been met. The other uses, while entertaining and, good information, that's not what we're looking at today. So as far as ITD's hands are tied, I don't even know what that means. I was on KMPO, I've spoken to ITD, and they have said nothing. They said that their decisions are not based on commissioner decisions on development. So the subdivision has to go through, especially a major subdivision. The minor subdivision is a less intense use, but that could only result in 4 separate parcels. So I don't believe that there's a need for a conditional zoning development agreement at this time. So I would be in favor of approving it without one. But if my co-commissioner won't budge based on the fact that we are here to hear the zone change and they've met all the criteria, then I would further discuss that.
Well, the applicant is here ready, willing, and able to discuss 3 residences in exchange for the zone change, and I think that we should entertain that. And I think there's nothing wrong with accepting that premise and then codifying it on the land itself so that they can develop it just to those 3 residences. So I would suggest that we move to remand it back to the hearing examiner for the conditional zoning development agreement.
So are you going to exclude the golf course? I mean, exactly what do you mean? So can they still have their 2, I don't know if it's 2 or 3 5-acre things and then leave the 35 acres with the main house? I mean, how detailed do you want this agreement to be?
Well, in a perfect world, if the owner was open to the 16 and 2/3 acre lot sizes, because at this point, if I heard correctly, it's nothing more than a dream at this point. There probably isn't funds to develop it, and there's probably not enough water, quite frankly. I mean, that's another issue too. I don't know.
It's not an issue before us tonight.
I understand. So, but with that said, I prefer if the owner would be willing to look at 16 and 2/3 acre. I don't know if we're in a position, and I'm sorry just because of my newness here, to have a negotiation on that, but I wonder, can we send it to the hearing examiner and give the hearing examiner options to see what the owner is willing to do?
Yeah, and that negotiation would happen after this decision because the record is closed at this point.
Yeah.
So, but those, if at least two of you are open to, considering negotiation of a conditional zoning development agreement, then we could go forward with that, and then we would have the negotiation after after we're authorized to do so.
So then how many parties are involved in the negotiation? Because if you have, you have one commissioner saying he wants only 3 at 16 acres each. I say I'm not going to, be that restrictive. If they want 2 5 acres and a 35 acres, then I don't think that's our job.
I would suggest that we leave that part open in negotiation.
Sure, three residents on the 50 acres, and
Yeah.
they figure
I
that
agree
out.
with Bruce. I think that's the way to go on this.
Okay.
Is there a motion?
I move that we remand it back to the hearing examiner to come up with a solution for 3 residences on the 50 acre lot.
I second the motion.
Bill Brooks.
Aye.
Commissioner Matari.
Aye.
Chair Duncan.
Nay. So while I agree with the reconsideration, absolutely, I believe that there were big missteps here. I don't like the idea of being even more restrictive when we are just looking at a zone change. So with that, it is 7:27, meeting adjourned.
Okay. So at least there's a door open.